a complete guide to Rhode Island personal injury lawsuits. If you are injured because of someone else's carelessness, you may be wondering what happens next. Do you have a personal injury case? Do you need to file a lawsuit? How long do you have to act? And how do you know what your case may actually be worth? In this video, we're going to walk through how Rhode Island personal injury claims work, what you should do after an injury, the laws that may affect your case, what types of compensation may be available, and what to expect if your claim turns into a lawsuit. This is a general overview because every case is different. Even one small detail can change the laws, deadlines, or insurance coverage that applies. The best way to understand your own situation is to speak directly with a Rhode Island personal injury lawyer. Importantly, this video should not be taken as legal advice and is for educational purposes only. If you want legal advice, contact Marasco and Nesselbush for a free, no-obligation legal consultation with an experienced Rhode Island injury lawyer. So, let's start with the most basic question. What is a personal injury case? In simple terms, a personal injury case may arise when another person, business, or organization fails to act reasonably, and someone gets hurt as a result. That could involve a driver who causes a crash, a property owner who fails to address a dangerous condition, a healthcare provider who makes a preventable medical error, or a company that puts an unsafe product into the market. The harm may include much more than the initial physical injury. It can lead to medical bills, missed work, reduced earning ability, pain, emotional distress, and lasting changes to your independence or quality of life. When someone dies because of another party's wrongful conduct, the person's estate and certain surviving family members may also have rights under Rhode Island's wrongful death laws. How do you know whether you have a personal injury case? Most personal injury claims come down to four basic questions. First, did another party owe you a legal duty? That simply means the person or business had a responsibility to act with reasonable care. Drivers, for example, have a duty to follow traffic laws and operate their vehicles safely. Second, did that party fail to meet that responsibility? Maybe a driver was distracted. Maybe a business ignored a dangerous condition. Maybe a medical provider failed to follow the accepted standard of care. Third, did that conduct cause or contribute to your injury? It is not enough to show that someone made a mistake. There generally needs to be a clear connection between what they did and the harm you suffered. And fourth, did the injury cause measurable losses? Those losses might include medical expenses, lost income, pain, physical limitations, emotional harm, and other economic or non-economic effects. Evidence such as medical records, photographs, witness statements, incident reports, and financial documents can help answer these questions. But every situation is different, especially when the other side denies responsibility or several parties may have contributed. A free consultation with a personal injury lawyer can help you understand whether the facts may support a claim. What kinds of cases fall under personal injury law? There are many different types of personal injury cases. Common examples include car crashes, truck accidents, motorcycle collisions, pedestrian and bicycle injuries, slip and falls, dog attacks, medical malpractice, unsafe products, and workplace injuries caused by someone outside the injured person's employer. Personal injury law also covers catastrophic injuries, such as traumatic brain injuries, spinal cord damage, amputations, severe burns, and other permanent impairments, as well as wrongful death claims. That is not a complete list. Some incidents can also fall into several different categories. For example, a commercial truck collision might involve the truck driver, the trucking company, a maintenance provider, the company that loaded the cargo, and potentially other parties. Identifying the correct type of case matters because it can affect which laws apply, what evidence is needed, who may be held responsible, and which insurance policies may provide coverage. Who is allowed to file a personal injury lawsuit? Usually, an injured adult files the case in their own name. If the injured person is a child, a parent, guardian, or another legally authorized representative may need to act on the child's behalf. If an adult is incapacitated and cannot manage the case independently, a guardian or other authorized person may be able to pursue the claim. In a wrongful death case, the lawsuit is generally brought through the deceased person's estate. A spouse or certain qualifying family members may also have related claims, depending on the circumstances. Determining who has the legal authority to bring a case can become complicated, especially when a child, incapacitated adult, or fatal injury is involved. That is another reason it helps to have a lawyer review the specific facts early. Is a personal injury claim the same as a lawsuit? Not exactly. A personal injury claim usually begins outside of court. The injured person or their attorney notifies the responsible party and the applicable insurance companies, investigates what happened, collects records, and seeks compensation. Many claims are resolved through negotiations without a lawsuit ever being filed. A lawsuit begins when a formal civil complaint is filed in court. The complaint identifies the defendants and explains why they are believed to be legally responsible. Filing a lawsuit may become necessary when the insurance company denies responsibility, argues that the injuries are not serious, refuses to offer fair compensation, or simply stops negotiating. A lawsuit may also be necessary to obtain evidence through the court process or to protect the claim before the filing deadline expires. Once a lawsuit is filed, the case moves into a more formal process. The parties exchange information, question witnesses, take depositions, consult experts, and present legal arguments to the court. The case can still settle at almost any point. In fact, many claims settle after a lawsuit has been filed. But if the parties cannot reach an agreement, a judge or jury may ultimately decide responsibility and damages. One very important point is that keeping an insurance claim open does not necessarily protect the deadline for filing a lawsuit. Ongoing negotiations should never be assumed to pause or extend that deadline. What should you do after an injury? Your health comes first. Seek emergency medical care when necessary. Attend follow-up appointments and complete the testing, therapy, or rehabilitation recommended by your providers. Medical treatment is important for your recovery, but it also creates documentation showing what injuries you suffered and how they progressed. Some injuries, such as head injuries, internal bleeding, and spinal cord injuries, are not always immediately apparent. So you should seek medical treatment, even a basic evaluation, if you have been involved in a personal injury. You should also report the incident to the appropriate party. Depending on what happened, that might mean contacting the police, notifying a property owner, reporting the injury to a business, informing your employer, etc. When possible, photograph or record the scene, the dangerous condition, vehicle damage, visible injuries, and the surrounding area. Get the names and contact information of any witnesses. Save damaged clothing, defective products, electronic messages, receipts, and any other materials connected to the injury. Keep your medical bills, discharge instructions, prescriptions, wage records, and documentation of other accident-related expenses. Of course, someone who has suffered a serious injury may not be able to do all of this. You may be hospitalized, unconscious, or simply focused on getting through the immediate medical crisis. That does not automatically prevent you from having a case. Family members may be able to preserve basic information, and an attorney can help obtain reports, contact witnesses, request surveillance footage, and preserve other evidence before it disappears. What mistakes can hurt a personal injury claim? One common mistake is delaying medical care. If you wait too long to receive treatment, the insurance company may argue that you were not seriously injured, or that something else caused your symptoms. Gaps in treatment, missed appointments, and failure to follow medical recommendations may also be used to challenge the severity of the injury. Another mistake is giving a recorded statement to an insurance company without understanding how the statement may be used. You should always provide truthful information, but you should not guess, speculate, or accept blame before the incident has been fully investigated. Be cautious about signing releases or accepting an early settlement before the full medical outlook is clear. Once a claim is settled, you generally cannot go back and ask for more compensation because your condition became worse or you later learn that additional treatment was necessary. Social media can also create problems. Photographs, videos, comments, and location data may be reviewed by insurance companies and defense attorneys. Even an innocent post can be taken out of context and used to argue that your injuries are not affecting you as much as you claim. An early consultation with a lawyer can help you avoid mistakes like these without committing you to filing a lawsuit. Who may be held responsible for your injury? That depends on how the injury happened and who had a legal responsibility to prevent it. In a car accident, the responsible party may be a negligent driver. If that driver was working at the time, the employer may also be involved. In an unsafe property case, responsibility may fall on the property owner, property manager, tenant, maintenance company, or contractor. A medical malpractice claim may involve a doctor, nurse, hospital, clinic, or another healthcare provider. A defective product case may involve the manufacturer, distributor, retailer, or other businesses connected to the product. Commercial vehicle accidents may involve trucking companies, vehicle owners, maintenance providers, cargo contractors, and other parties. Certain claims may also involve government agencies, public employees, or multiple people and businesses whose conduct combined to cause the same injury. Identifying every responsible party matters. Different parties may have different insurance policies, possess different evidence, or blame each other for what happened. Police reports, contracts, maintenance records, surveillance footage, witness statements, medical records, vehicle data, and expert analysis may all help determine who should be included in the claim. How long do you have to file a lawsuit in Rhode Island? For many Rhode Island personal injury cases, the general deadline is 3 years. In a typical accident case, that 3-year period usually begins on the date the injury occurred, not when the insurance company finishes reviewing the claim or when settlement negotiations end. But the 3-year rule does not apply in exactly the same way to every case. Different rules or exceptions may apply to medical malpractice, wrongful death, injuries involving children, claims against government entities, and injuries that could not reasonably have been discovered right away. Some cases also have separate notice requirements that may be much shorter than the deadline for filing the lawsuit itself. Missing the applicable deadline can prevent you from recovering compensation, even if your injury is serious and the evidence of fault is strong. Because the correct deadline depends on the case type and the specific facts, it is safer to speak with an attorney early rather than assume you have plenty of time. What happens if you were partly responsible? Rhode Island follows what is called a pure comparative negligence rule. That means being partly at fault does not automatically prevent you from recovering compensation. Instead, your recovery may be reduced according to your percentage of responsibility. For example, suppose your total damages are found to be $100,000, but you are determined to be 25% responsible for the accident. Your recovery would be reduced by 25%, leaving $75,000. Insurance companies often use comparative negligence arguments to try to reduce what they pay. But the percentage suggested by an insurance adjuster during negotiations is not automatically a final legal determination. If the case reaches trial, the judge or jury decides how responsibilities should be divided based on the evidence. Are there special rules for certain personal injury cases? Yes, and this is an important area to understand. Personal injury cases do not all follow the same rules. The applicable deadlines, notice requirements, insurance issues, available damages, and legal procedures may change based on the type of case, the identity of the defendant, where the injury occurred, and many other details. The examples we are about to discuss are only a few of the special rules that may apply. They are not a complete list. Claims against government entities are one example. A case involving the state, a city, a town, a government employee, a public vehicle, or public property may be subject to special notice procedures and possible limits on damages. Certain claims involving defects in municipal roads or bridges may require written notice within a much shorter period than the normal personal injury filing deadline. Workplace injuries can also involve separate rules. Workers' compensation may provide benefits when someone is hurt on the job, but if the injury was caused by an outside party, the worker may also have a separate personal injury claim. That outside party could be a driver, contractor, property owner, equipment manufacturer, or another business that is not the injured person's employer. The workers' compensation case and the third-party personal injury case may interact through reimbursement, subrogation, and other legal rules. Uninsured and underinsured motorist claims are another example. If the person who caused a crash has no insurance or does not have enough insurance to cover the injuries, compensation may be available through another applicable auto policy. The coverage available depends on the selected limits, the language of the policy, who is insured, and other facts surrounding the collision. Rhode Island also has specific laws dealing with dog bites and animal attacks. In some situations, an owner or keeper may be held responsible without the injured person having to prove that the owner already knew the dog was dangerous. But the analysis may change depending on where the attack occurred and the circumstances surrounding it. Again, these are only examples. Medical malpractice cases, wrongful death claims, product liability cases, claims involving children, and many other case types may all have their own statutes, exceptions, and procedural requirements. You should not assume that a general rule mentioned online automatically applies to your situation. One detail can completely change the legal analysis or deadline, so it is best to discuss the actual facts with a Rhode Island personal injury lawyer. What evidence is used to prove a personal injury case? The evidence generally needs to establish three things: what happened, who was responsible, and how the injury affected you. Evidence about the incident may include photographs, video, police reports, incident reports, witness statements, surveillance footage, dash cam recordings, cell phone records, vehicle data, and physical items connected to the injury. Evidence about the injuries may include emergency room records, diagnostic testing, treatment notes, surgical records, prescriptions, rehabilitation documentation, and recommendations for future care. Financial records may include pay statements, tax documents, medical bills, receipts, and proof of other out-of-pocket costs. In serious cases, attorneys may also work with medical specialists, accident reconstruction professionals, engineers, economists, vocational experts, life care planners, and other qualified professionals. No single document usually proves an entire personal injury case. Strong claims are often built from several pieces of evidence that support each other. What types of compensation may be available? Personal injury compensation is generally intended to address the losses caused by the injury. These losses are often divided into economic and non-economic damages. Economic damages are the financial losses that can usually be documented through bills, employment records, and receipts. They may include past and future medical expenses, lost wages, reduced earning ability, property damage, rehabilitation expenses, transportation costs, home assistance, and other injury-related financial losses. Non-economic damages address the human effects that do not come with a fixed invoice. These may include physical pain, emotional distress, mental anguish, loss of enjoyment of life, disability, scarring, disfigurement, reduced independence, damage to a marital relationship, and other personal losses. This is not a complete list. The damages available depend on the type of case, the evidence, and the specific ways the injury has affected the person's health, finances, relationships, and future. A fair evaluation should also consider future consequences, not just the bills that have already arrived. How much is a Rhode Island personal injury case worth? The honest answer is that case values can vary enormously. Two incidents that sound almost identical at first can result in dramatically different case values once you look at the injuries, evidence, legal issues, and insurance coverage. There is no reliable average settlement and no universal formula. A temporary injury that heals with limited treatment is going to be evaluated very differently from a spinal cord injury, traumatic brain injury, or another condition that permanently affects someone's ability to work and live independently. The type of case also makes a huge difference. A car accident claim may involve very different liability, evidence, and insurance issues than a medical malpractice case, defective product lawsuit, wrongful death action, or claim against a government entity. Even within the same general type of case, the value can vary tremendously based on the specific facts. Case value may be affected by the nature and severity of the injuries, whether the condition is permanent, the cost of past and future treatment, lost income, reduced earning capacity, and the effect on everyday life. It may also depend on whether responsibility is clear, whether the injured person shares some fault, how strong the evidence is, how many parties are involved, and what insurance coverage or other sources of compensation are available. In major injury cases, experts may be needed to estimate future medical needs, lifetime care costs, and the effect of the injury on the person's ability to earn income. That is why online settlement calculators and broad averages are often misleading. They cannot account for the facts of your case, the type of claim, the quality of the evidence, or the insurance that may be available. The only meaningful way to estimate a case is to review the specific facts, injuries, records, and legal issues. Even then, no responsible attorney can guarantee a particular result at the beginning of a claim. How long does a personal injury case take? There is no fixed timeline. The length of the case may depend on how serious the injuries are, how long treatment continues, whether the long-term medical outlook is known, and whether the other side disputes responsibility. Cases involving multiple defendants, complex evidence, expert testimony, or disputed insurance coverage will often take longer. Settlement discussions may begin once the evidence and damages have been documented. But settling too early can create problems if future medical care, permanent limitations, or reduced earning ability are not yet understood. If a lawsuit is filed, the parties may go through discovery, depositions, expert review, motions, mediation, and other court procedures. Some lawsuits settle early in the process. Others settle shortly before trial. A smaller number require a judge or jury to decide the outcome. The goal should not be to make the case take longer than necessary. But it is also important not to rush into a resolution that fails to account for the full impact of the injury. What does a personal injury lawyer actually do? A personal injury lawyer can investigate how the injury happened, identify potentially responsible parties, and preserve evidence before it is lost. The legal team may obtain police reports, surveillance footage, maintenance records, employment documents, medical records, and insurance policies. They can communicate with insurance companies, respond to fault arguments, calculate current and future damages, and consult experts when necessary. If the case cannot be resolved fairly through negotiations, the attorney can file the lawsuit, handle discovery, take depositions, present legal arguments, and prepare the case for trial. Just as importantly, a lawyer can explain your options at each stage, so you can make informed decisions while focusing on your medical recovery. As we mentioned, there are many factors that need to be assessed in a personal injury lawsuit. These factors can affect legal processes, timelines, at-fault parties, responsibility, damage calculations, negotiations, etc. An experienced personal injury attorney navigates these complex issues to ensure that you, the client, receive the highest possible level of compensation for your injuries. Why choose Marasco and Nesselbush? At Marasco and Nesselbush, our attorneys represent injured people and families throughout Rhode Island and southern New England. Our 18-attorney team brings more than 350 years of combined legal experience to cases involving serious injuries, motor vehicle accidents, medical malpractice, disability claims, unsafe properties, and wrongful death. We have recovered more than $500 million for our clients. With offices across Rhode Island, we have local, dedicated attorneys who are a part of your community, who know the courts, and have the resources and experience to represent you to the fullest extent. Our bilingual team is available to assist clients in English and Spanish throughout the legal process. Eligible personal injury cases are handled on a contingency fee basis. That means there are no upfront attorney fees, and you do not owe attorney fees unless we recover compensation for you. You only pay legal fees after you have been awarded compensation for your injuries. No compensation, no legal fees. What should you do next? If you were injured in Rhode Island and are unsure whether you have a case, the most important thing is to get information before making decisions that could affect your rights. Prioritize your medical care. Preserve whatever evidence you can. Be careful when dealing with insurance companies, and do not assume that an open claim protects the deadline for filing a lawsuit. Every case depends on its own facts, and the laws can change significantly based on the type of injury and the parties involved. Contact Marasco Nesselbush for a free, no-obligation consultation. We can listen to what happened, review the available information, and explain the legal options and next steps that may apply to your situation. And remember, you pay no attorney fees unless we recover compensation for you.